Welcome to another episode of Mailbag Monday, where Chris and I are answering all of your marketing, AI, data, and legal questions today. So, Chris, today, Chris and I are not lawyers, by the way. Fred asked if you are inputting a blog post into ChatGPT to help with SEO or to help with classification, what are the legal ramifications of using generative AI? So it sounds like this is a copyright slash ownership question.
So it's tricky. And again, as Katie said, we are not lawyers. We cannot give legal advice. If you would like a lawyer, go check out my friend Ruth Carter. They have a law firm called Geek Law Firm, geeklawfirm.com. If you need actual legal advice from someone who's qualified to give it. Now, in terms of the questions Fred is asking, if you're concerned about there's two different angles here. One is if you're putting stuff into someone else's system, read the terms of service, because you are giving up some of your rights to that stuff. They will use that stuff for like training their models. OpenAI says this very clearly when you create an account. It says we will be using your data. So there is that aspect, and if you add enough data, obviously. You are helping train the model to sound more like the content you are submitting to them, which will, in time, with enough people, kind of remove a strategic advantage if you have a very unique way of writing, because that gets added to the pile of and teaches the AI how to write like you. So that's one aspect. For the second aspect, which is if you are using the content created by a service like ChatGPT, it depends on the form it takes as to what its legal status is. In the USA, the UK, and now I believe the EU as well, content created by a machine is ineligible for copyright because it was not made by a human. Naruto versus Slater in 2018, that law case where the chimpanzee took a selfie, and after a number of lawsuits, the court ruled the content was not created by a human. Copyright law only applies to humans. So if you are publishing content that a machine has made, that is ineligible for copyright. It cannot be copyrighted. It's public domain, which means anyone can use it. If you are using a machine to ideate and then you, the human, do the writing, that content is protected by copyright law because you, the human, created it, even if a machine wrote the outline, because ideas can't be copyrighted anyway. So the actual output was copyrighted. If in this case, if you're using it to do keyword analysis for SEO, if you incorporate like whole chunks of text from the machine into your content, those chunks of text are not under copyright. And you can actually test this. There's a number of tools like Zero GPT where you can copy and paste text, and it will say this whole paragraph here looks like it was generated by machine, and because of a scientifically a technique called perplexity. AI tools have linguistic patterns to how they write that are detectable by other machines. So those are kind of the major legal ramifications. It's yes, you're giving up some of your rights when you put stuff in the machine, and what the machine puts out, you have no rights to.
I'm still stuck on someone taking a monkey to court. I mean, what a time to be alive, Chris. But no, it's interesting because it's like any other piece of software you use. If you use social media, if you use, portals with your medical professionals, if you use, email, Gmail, whatever service you use, Yahoo, Hotmail, whatever, those systems are collecting information on you. So ChatGPT is no different than any other system, even if you're not putting in your first and last name and your date of birth and your favorite color or whatever. It's still collecting information. And as Chris mentioned, look at the terms of service and decide whether or not you are comfortable sharing that information, because these systems do not really give you the chance to opt out. Like, it's sort of an all or nothing right now, where you're either using it and sharing your information or you're not using it at all. And if you're not using it all, then that means that you likely either have the skill set to build your own, which is private, or you're just not, in the conversation about these tools. And so that's really what it comes down to. And, to your point, Chris, You can't copyright something machine generated because the machine is generating it based on all kinds of bits and pieces. So think of it like a collage, of found objects where here's a rock and here's a stick and here's a leaf and here's a piece of yarn. Let me put them all on a piece of paper and call it art. Well, it's not art, it's what my 5-year-old did, but it's all just like stuff that they mash together. And that's in a very, very, very simplistic way. That's what these systems are doing, is they're just mashing together found information.
Yeah, I mean, if you want to get slightly technical, they're not even doing that. They're mashing together patterns they've seen in found information. So it's abstracted. This is the heart of copyright cases about people saying, "Hey, you scraped my content. You don't have the right to do that." And depending on where you live, the courts will disagree or agree. So in the EU says models that use training data are violating copyright. In Japan, they ruled the opposite direction. They said training data does not violate copyright because the original work is not being replicated. So it depends on where you live. But to Fred's question, those are the two major implications. You're giving information unless you're using either a premium tool of some kind where there's an agreement that the company will not use your information, or you're using a private tool like the GPT for All desktop app with the models that you download. That tool, which by the way, I would strongly encourage, if you were working with any kind of sensitive information, you should be using that tool because the data never leaves your laptop, which is important. That's the one side. The other side is the output. If a human has made it, it can be copyrighted. If a machine has made it, it cannot be. And if it's a blend, only the portions that the human made are eligible for copyright. So those are the major legal ramifications. There are others too. For example, if you have it generate content and you don't QA it and it says something stupid, you are responsible for what is on your blog. Right? So even if a machine made it, you are still responsible as the publisher of it. So those are some considerations too.
Makes sense. Lots of questions about copyright over the next few weeks. It's, people have questions. They're using these new systems. What does it mean? So, stay tuned for more there.
Yep. Stay tuned. We'll talk to you next time. Thanks for watching today's show. If you liked it, please hit the subscribe button and bell to be notified when we publish new shows. If you want to catch all our content, including back episodes, subscribe to our free Inbox Insights newsletter at trustinsights.ai/newsletter. Want to talk about what you've enjoyed? Join our free Slack community, Analytics for Marketers, at trustinsights.ai/analyticsformarketers. Need help with your marketing, data, analytics, or AI? Drop us a line at trustinsights.ai/contact. Thanks for watching. I'll see you next time.